Welcome to the podcast. I'm your host, Chris Van Dijk, and today I have Taryn Cowan with me. The podcast is about building right with Windows design and the business of building better. And what better than to have Taryn come in to talk about what she does with the business law. We all know in construction we have terms and conditions and contracts, and some of them are not favourable to the person who's actually signing the contract. There's a lot of information in these documents, and it's always important to get legal advice, correct?
Absolutely.
So, Taryn, if you could just tell us what your role is and what you do.
Sure. So my name's Taryn Cowan from Cowan Law. I'm the solicitor director. I've been practicing as a lawyer for nearly 15 years this year. And I specialise in business law, so anything to do with businesses. That's my niche, and I don't deviate from that. And I'm very passionate about being proactive when it comes to legal risk and minimisation.
Yep.
And that includes pretty much what you've said about making sure you're getting advice before signing things or understanding your rights and obligations before committing to a job and things like that.
So, Taryn, when did you start your journey in law?
A long time ago now. So I graduated from uni and then I actually went into criminal law.
Mm-hmm.
I stayed there for a little bit and realised it wasn't for me. And then I moved into the city and started commercial law, so business law, as we call it in the suburbs.
Yes.
And it just snowballed from there.
Okay, and you said earlier it's your passion.
Yes.
What tell us a bit about your passion.
I suppose because I do the dispute side of legal issues, so I see how things go wrong, and it's always, in most cases, preventable, or you can minimise the cost and time that you've spent being involved in a dispute if you had done things earlier.
Yeah.
So the whole niche of my business is being proactive, early intervention, things like that, to make sure that you're getting things right at the start and
Yes.
not at the end when it's too late or you've got minimal options.
Yeah. So I know we've done business in the past multiple times, and
Yeah.
I think a big thing for us was the initial engagement when we look at picking up a contract
Yeah.
to do windows and doors, which is what we do, but also you have other niches as well, whether it be carpentry, building, multiple different types of contracts.
Mhm.
I think it's very important that they engage a solicitor to get that advice, right? I
Yeah.
mean, sometimes the documents are 1,300 pages,
Yep.
and it's a lot to go through.
Yep.
What's a common mistake that you see people make before, like, signing these documents?
Yeah, so it depends on who the client is. So if your client's a homeowner or a consumer, generally speaking, mistakes are always around communication, lack of communication, the trade's not putting things in writing, and then the customer saying, you didn't say that, we didn't agree to that, and that's how the dispute snowballs. If it's for someone where your client is an entity, a building entity or a developer or another trade, generally around scope and timing, delays and not following procedures with respect to requesting extensions and time and things like that can lock you in and create, again, disputes. And the overarching issue is that for both, depending on who your client is not seeking advice or steps earlier to resolve a dispute.
Mm-hmm.
Often they come once the dispute is escalated, and once it's escalated, the communication's broken down, and it's really hard to come to a resolution if you're not speaking to your client anymore or things are just really bad. So if you are in a situation where the dispute's escalated and you think that the communication's just broken down, that you should be seeking advice before that or around that time. Don't let it snowball.
I think it's hard too, right? Because some people they get quite upset and emotions get involved, and then they're at loggerheads, and
That's right.
and they just want to butt heads with each other.
Yeah, everyone has their side, and I always say to clients, if you haven't negotiated properly unless both parties leave unhappy, because you both have to compromise. But the longer the dispute goes on, the less chance you have of resolving the issues because both parties just get angrier and angrier. I see it all the time.
Yeah.
And then you're at a standstill and there's minimal options both parties can take, and both of those options involving courts and tribunals to escalate the issues which you want to avoid because they're costly and time they take so much time to run.
And sometimes going to court is actually going to cost you a lot more money than just saying, okay, I'm going to give you a deduction on the invoice, or I'm going to pay you some money, and then we don't have to go to court.
Yep.
Because it's not just time, it's energy, and then the amount of time and energy that you focus on this legal battle, which I like to call dead money.
Yeah.
Because you're not making money by doing it. It stops you from making money in other ways, right?
That's
and
right.
chasing more work.
Yeah, litigation is really costly and also takes so much energy and effort from the business owner who's running the case. You have to put on affidavits with like extensive knowledge of what you've done. If you haven't put things in writing, then you have to remember everything you've said to your client. It's a process you don't want to go down unless there's a big quantum of money involved.
Yep.
You want to try and resolve it beforehand and be proactive about disputes.
Yep.
And know when things are starting to break down that's when you should start speaking to someone, especially about how you can handle things better moving forward, just in case it does come to that.
And have you got an example that you could share with us today of one of these instances where you've had a client or a builder that ended up having to make stop going down the litigation path and communicate better with that person?
I've just recently assisted a builder. His communication with his client, who was a homeowner, was completely broken down. By the time he'd come to me, it probably was a little bit too late, and he was getting 10 emails a day from this homeowner with disputes about defects which he disagreed with. And by that point, you can appreciate that for the homeowner, this is everything to them. And the builder, you've got other jobs, you've got other things to worry about. Mm-hmm. So there's already a discrepancy between what is priority and what's not. So I was able to assist him to kind of focus on the key issues and formulate a table of issues to rectify with the homeowner before going to that next step. The homeowner had threatened to go to NCAT, go to fair trading. I gave him advice about that and whether I thought that was going to happen or not. And then we were able to give him some tools and next steps to try to resolve the issue. And he ended up meeting with the homeowner, utilising the paperwork that I'd done and advice that I'd given him, and was able to negotiate a way forward successfully. It did take some time, obviously, and it was really stressful, but he was glad that he had gotten myself involved because it was already escalating really quickly.
And I've seen I'm obviously in the industry myself, not in the law industry, but with windows and doors, and we've had it happen quite a few times where the emotions from each side escalate.
Yeah.
And sometimes you have to be that bigger person to take that deep breath, right?
Yeah, you do. And you have to, as a business owner, weigh up your risk versus reward. I always say that. What is your risk of just cutting your losses and say, fine, I'll rectify your window and we'll write that invoice off just for good faith and for customer service or whatever it may be, versus taking it further if you want to. I mean, that's a matter for you, but you have to balance that. And I'm definitely not in the business of wanting clients to pursue disputes just to make money. I think it's stupid. Yep. And I'm always telling my clients to be commercial about things. And that's why sometimes it's good to have someone else look at your matters or your contracts and things like that, because we're not viewing it from your personal emotions, as you just said.
Yeah.
We're looking at it black and white. Here's the facts, here's what you've done, here's what you haven't, this is what you need to do. Mm-hmm. And sometimes it can help to have that different perspective to zone you in and know what you need to do to fix things.
And understand what the potential outcomes and the cost to go after those outcomes are too.
A lot of people, I always see it online, a lot of people are like, I'll just sue them, I'll just take it to court. And they have no idea how much that costs. I'm happy to run a case. I love going to court. It's fun. It's exciting. It's good money, of course, but it's not good if you could do things to prevent that. The goal is to always prevent that stage.
And is it easy to just sue somebody?
No, it's really hard.
What are the steps that you have to take to sue? So for those people that have that mentality, we're just going to go and sue so-and-so, what are the steps that you have to go through?
You have to have a reasonable cause. You have to have a case, like a good position to sign off to say that you're ready to go to a court. Or tribunal's different. NCAT is where you handle home building disputes and things like that with builders and things. That's a bit more user friendly. So a homeowner could take a supplier or builder to court, it's a tribunal, fairly easily, and you can't have legal representation there unless you've been approved by NCAT. That's a bit different. That's more user friendly. But in terms of actually going to court, like the normal Supreme District Court, whatever it may be, you have to have a statement of claim. You have to have, usually before I would even file a statement of claim, I'd want to get a barrister's advice to make sure prospects are okay.
Cost money?
That costs money. You can't sign off on a statement of claim and go to court unless you have a good position.
Yes.
So for those types of disputes, we want to see it over a substantial amount of money to make it worth it.
Yep.
You know, we wouldn't want it to be anything small. If it's small, we should be trying to do a mediation or something like that.
Yeah. And with those steps, I mean, to get to court, it's a lot of time as well.
Yeah, you've got to prepare like a statement of claim, an affidavit, evidence. There's directions hearings where you go before the court and they set out timetables. It all takes time. Your lawyer and your barrister have to be there for everything. You don't necessarily, as the client, until you have to give evidence if there's a hearing and things like that. But even the court has an obligation to encourage parties to participate in alternative dispute resolution. It's under the Civil Procedure Act, so you have to try to work things through. They'll even order potentially a mediation or informal settlement conference to try and resolve the issue before it keeps going as well.
And sometimes the court systems are quite clogged up as
Yeah,
well.
absolutely.
And that, you might lodge all the paperwork and then you still have to wait 6 months, 12 months to go to court.
Sometimes, yeah.
And if you look at, what the cost is versus the interest minus what it actually costs you to go to court, most of the time, would you say that, in those type of cases, the smaller type of cases, that it's not even worth it?
No, usually it's not. And that's something that I would give advice on, and I'm not hesitant to do that. I'm realistic about things, especially if it's, a smaller quantum. And I understand people think that, a couple of grand is a lot of money. Of course it is a lot of money. It's a lot of money to me. It's a lot of money to most people. But when you weigh that up against the money to proceed further, the stress of it, it's usually not worth it. And that's the advice that I've given clients time and time again.
Well, I remember I had an incident several years ago where we had a client that didn't want to pay us, and I think it was in the vicinity of around about $6,000 or $7,000. And I came to you and I asked you for your advice, and you pretty much gave me that. Is it worth throwing good money against bad money? I think we had that conversation. It was, after having your advice, it was quite quick for me to understand that, no, you're exactly right. If you are hot-headed, you can take it to court, but it's going to cost you 10 times as much as what it's probably worth in the long run, right?
It's important to try to definitely try to send like a letter of demand or engage a lawyer to do that for you. I'm a big believer in that, and see where you land with that. Normally the response or lack of response will indicate what you can do next. But in terms of a quantum of that amount, it's not worth taking it further unless you're prepared to do the work yourself, which you can in the local court. It's, again, user-friendly for civil claims, which is small claims, which is under $10,000. It's designed for people to kind of do it their own way without lawyers involved. So you absolutely can, and you can have a lawyer give you advice about that process before you do it.
Yep.
But it is time consuming, and everyone I know that's been through small claims says it's really stressful. Obviously, it's uncommon for people to be involved in court proceedings. It's unnatural, and maybe you'd be better spent that time and energy on your business and moving forward.
Yeah.
And not to mention from a customer perspective, suing clients and customers isn't exactly the best reputation that you want to have. You want to be seen that you work with your customers and try to resolve things quicker.
I think that's a sticking point too, is your reputation in the end, right? Like if you want to be going after your clients for not paying you, that's also something that you need to take into consideration. The Security Payments Act. So if we just touched on builders and clients and suppliers alike.
Yep.
Now, there is a lot of people out there that are contractors, particularly for labour. Yep. And a lot of the invoices say under the Security Payments Act. Now, have you got any advice for any general advice, of course, and we've spoken before, anybody listening should always seek legal advice and not take our general advice here on the podcast as their own legal advice that they've sought. But have you got any recommendations for contractors that are trying to get paid that haven't been paid and have used the Security Payments Act on their invoicing? What are the steps that are involved for that?
The Security Payment Act is very time specific, so you need to follow it to a T. So you need to be researching the Act, or there's a whole bunch of websites available that literally step out what you need to do. You have to follow that to a T. So it says if your client hasn't paid you within whatever days it is, 7 days, within 2 days you need to do this. Within 5 days from that you need to do that. You have to follow that process. If you don't follow that process, then you can't utilize that avenue. So there's 2 ways that you can claim a dispute. You can a debt. You can go down that route,
yes,
or you can go down the small claims and the court route. Most clients prefer the small claims route because the Security of Payment Act is so time constrained, and they miss it.
Okay.
They've missed the deadline. They haven't followed the procedures properly that's set out in the legislation, and they miss those timeframes, so they have to move over to this side.
So once you miss those timeframes that are set out, if it was 2 days and you didn't do it in 2, that's it. You no longer have a claim.
If it's unreasonable to not let you move forward, it's dependent on what the adjudicator will decide.
Yep.
But generally speaking, yes, that's what it's there for a reason. You have to follow the procedure.
Right, so it's not just as easy as, I'm going to take you to security payments.
No, you have to follow it very closely.
So variations on jobs, we're going to move to something else. So probably a couple of years ago, I came to you to get terms and conditions done for us because CVD, we moved into the residential space and the payment terms are significantly different to the commercial terms.
Yep.
Commercial contracts are quite lengthy. And there's a lot of terms in there that favour the builder. But when you're doing supply only and you're supplying cost of goods, the goods to people, that you can actually create your own terms, right?
Yep.
So can you give us a bit of a run through on what's important to understand when you do go down that route to undertake terms and conditions for sale for your business if you're doing supply only?
Everyone should have a contract, and as you rightly said, if you're a supplier and your customer is a consumer, then you can have terms and conditions drafted. If you're a builder, you can utilize the HIA, MBA building contracts. They're pretty balanced, but the main point is to make sure that you've got some form of contract in writing, and within that, you want to make sure that you understand how variations work and what the procedures and process is for variations to be issued.
Yep.
I find a lot of people get stuck because, generally speaking, for your bigger contracts, the variations are one-sided, so they can only be issued by the principal. The principal is the person running the site, and they're the ones who have issued the contract. And that means that if you need a variation, you can't ask for one because the contract says you can't. They have to issue you with one. So that's one of the issues that I always look at when I'm reviewing a contract for advice, just to try to get some leniency around variations and being able to potentially issue them yourself if it's needed.
And I find that a lot of the times the client will request you to undertake the work that's not in the contract, which is a variation.
Mm-hmm.
And how important is it not to undertake that work without getting a written agreement?
It's so important. I had a dispute not that long ago relating to that exact issue. The tradesman performed the variation, and then of course it came to payment time, and the customer said, "I didn't agree to this." And there was a he said, she said. He didn't write it down. He didn't get it in email. It was on phone calls, and that's not good. We want everything in writing, and I understand as a tradesperson it's hard to take the time to write things down, write it in an email, write it in even just typing up a variation, getting both parties to sign off. But that's all you have, and you have to perform that part of your business properly, or you're just exposing yourself completely. If you don't have it written down and signed off and approved in writing, they could just say it didn't happen, and then it's your word against theirs.
And then you go with, we've got the excuse that a site instruction does not also constitute a variation, because that happens a lot too, right?
That's right.
You've got the site form and he's issuing instructions to the contractors to say proceed with these works.
Yep.
Here's my approval.
No.
But that doesn't constitute
It
a
doesn't.
variation either,
No,
does
it
it?
has to be a formal direction variation following the procedure that the contract sets out.
We set pricing.
Yep, that's right.
And a lot of the time, contractors will do the work, expect to be paid,
Mm-hmm.
and it doesn't happen.
No,
And do you find that you're seeing that more and more often now?
with variations.
Yeah.
Yeah, I am. And it always comes down to a lack of communication and things missing and clients admitting, oh, look, yeah, I suppose I didn't send that email, or I thought the foreman exactly giving me a quick phone call saying it was okay, was approval. And that is because they don't understand the contracts they've signed.
Yep.
This is it all. Everything I'm saying today is going to circle back to the same point, but it's because it's so important. If you don't understand your rights and obligations, your risk factors, before you step on the site, how can you understand what you need to do when things aren't going in your favor if you don't even know what the contract is that you've signed? That always happens. I didn't know I had to send an email within 3 business days to direct them to issue a variation and approval. I didn't know I needed to do that. Well, it's in the contract. If you had got advice on it beforehand, you'd be in a better position to negotiate and understand where you need to move.
So what's your top 5 things before you sign a contract?
So legal advice, absolutely, especially if it's a lengthy contract. I just think given the quantums that are involved in those lengthier contracts, it's silly not to get advice on it. You're a tradesperson and you're fantastic at your job, but you're not a lawyer. And that's what we're here for, is to review it and give you advice. It allows you to be in a better power position, especially when it comes to disputes down the track relating to terms. You can say, well, no, the contract says this. You know, I've had clients do this and they're so much more confident negotiating when they understand what the contract is. Insurance is a big one, obviously, and you should always seek advice from an insurance broker relating to specific insurance requirements relating to your site.
Which is also in the contract that you would
Yep,
get.
and you want to make sure it's appropriate to the contract. It matches the contract. The contract will dictate what type of insurance requirements you need. You want to make sure that any work health and safety requirements are met. Clients have generally site-specific inductions that you need to do. And if you what type of indemnities you be giving,
Yes.
what that looks like, and what an indemnity is. It's where you're essentially saying that if any of these circumstances occur, the other party isn't liable at all, and they're normally pretty onerous on the smaller party.
Yes.
And that's something that I always look at closely. And probably, what are your exit options? What happens if there's a dispute? Because you need to kind of understand where you're sitting with that as well.
Mutual termination.
Yeah, that's a good one. So it's normally called termination for convenience, and generally in 90% of contracts I review, it's one-sided. Sometimes I'll get a surprise and I'll see that it's for both parties. But yeah, you want to make sure you can get out if the contract isn't working, or there's a procedure at least that you can take to assist with that.
And I think important, would you also believe that the important one is that if the builder or the client can get out of the contract with ease,
Mm-hmm.
that you should also have that ability to, or
Yeah.
have it removed?
Yeah, I do. The termination for convenience clauses are twofold. So sometimes they're good, sometimes they're not. They're not good if you don't want your client to get out, right? You've committed, you've allocated time, resources to your contract, and if they can just pull the plug on 30 days notice, that's going to impact your business. But they're also good because you don't know what the future holds, and there's so much issues in the construction industry that it's better to try to have some form of exit if you can. There's usually exit options around breaches and insolvencies, but again, most of the time it's in favour of the principal, the person issuing the contract, than the receiver of the contract.
So it's important to get that properly reviewed.
Absolutely.
Yeah. So when it's not your fault and delays happen on site, but if there's a delay that's yours, what's the legal right to and legal move to protect yourself?
So the first thing is you always go back to the contract. What does the contract say? Follow that procedure. It'll normally set out exactly what you need to do. And if you've had it reviewed and negotiated, then you'll be in a better position to do that, notify the client as soon as you know that there's going to be a delay. In writing, making it known that you're following the procedure of the contract, you think there's going to be a delay, it's not your fault, this is the reasons, and then you can follow that procedure. The reason you want that is because you're aiming for an extension of time. It's called EOT. And if you haven't followed those prior steps, then generally the contracts say you won't be granted an EOT. So you have to follow the contract really closely.
So the extension of time, can you touch on that for people
Yeah,
that
so
don't understand what that is?
an extension of time is generally in a construction contract, you have a program that's pretty stringent. You have to follow those time milestones very carefully, both parties. And if you don't meet it, you need to apply for an extension of time so that the dates go out. And generally, they're only on limited circumstances, such as like breach by something of the principal, or an unforeseen event, or like COVID or something like that. I always look at those because they don't really consider the practical elements of the person performing the work, and only you would know what you think could happen potentially that would cause an extension of time as the tradesperson. So you should be looking at that closely to make sure it considers your needs and your risks as well.
So I've seen some shocking contracts in the past and got some advice from you on those as well. There is some builders out there that actually have it in the contract that if there's a delay from another trade,
Yeah.
that you're still liable.
Yeah.
So like if there's supposed to be a hole in the wall for me to put a window and that hole's not there, then it's still my fault.
Yeah.
Have you seen many of those contracts come out?
Yeah, and they're always the types of clauses that we want to change. The contracts are just obscene at the moment. I think a lot of lawyers in business law would agree. They're so onerous and one-sided, and that's why it's important to get them looked at, because you want to make sure that you're able to move. If you have no movement, then if the contract says the hole in the wall is your fault, then it's your fault.
Yeah.
You know, you have to go with that process.
And once you sign on that dotted line, how hard is it to get out of it?
Hard.
Yeah.
Yeah.
And money and time consuming?
Money and time, you'd have to prove some kind of equitable principle or common law principle. That means court cases and things like that present your position similar to that. You can rely on that in court. That requires a court application to say that the contract is, oppressive, or there's been, someone hasn't performed their obligations properly. It's hard. And the cost of that is so much more than the cost to review it initially and getting advice on it.
So that's another thing. Like some people get very excited that they're about to win this project,
Yeah.
and it might be $250,000 or 100,000 or 2 million, and they might think, oh, that's the biggest contract we've ever got. And then it's like, okay, to review a contract could be a few $1,000s, depending how big it is.
Yep.
And they skimp on that.
I know. I don't understand. As a person providing the service, probably a bit biased, but I don't understand that. You wouldn't, generally, you wouldn't buy a house without getting your contract reviewed by a conveyancer at a minimum. So why on earth would you sign a construction contract for that amount of money and not have it legally reviewed? It's crazy. The higher the quantum, especially, the more risk there is in the contract. The lengthier they will be, the harder they will be.
And how have you seen, and one, have you seen, and two, if so, how many contracts come across from your clients that you've then advised them not to sign because they were so onerous on the builder that regardless of how much profit they're going to make on the job, it's just not worth it?
Yeah, I have. I've had to do that a few times, and majority of the time they will proceed with the contract because it's hard at the moment. People are trying to just run their business day to day, and it's difficult for people to say no to money, or the thought of the amount of the contract sum, whatever it is. But my job is to advise, right? I always use this analogy to clients. I'm just the car, they're the driver.
Yep.
So they get to dictate where their business goes. My job is to advise you, give you the tools to understand where your position and risk is. You make the decision on what you do. It's your business, it's not mine. So I obviously do my best and try to put it in terms that they understand, and then it's up to them to take that advice or not.
And have you seen any of those go horribly wrong?
Yes, I have, Chris. Yeah, I have. And I told you so. No, it's not told you so.
That's a hard one, isn't it?
It is hard. It's hard, but they have to learn the hard way. And I often find it's the less experienced business owner that's making those mistakes. You know, the younger builders who are focused on, you know, performing their jobs, and they don't take this side of their business seriously at all until something happens and it's so bad that they have never even thought about getting a lawyer before, and they don't know what to do, and they're stuck. Tends to be that demographic. The more sophisticated business owners that have been burnt before.
You've been burnt, yeah, many times. Seasoned
business owners that have been burnt by a contract. They're the ones that are sending everything to me. Look at this. Look at anything.
Yeah.
Look at this. Look at this. Which is good. That's the way it should be.
Well, that's, you know, like we said before, the cost of having it reviewed and getting some advice is minor compared to if it went horribly wrong.
Yeah.
Like you could make $5,000 on the job, right? For instance, or let's say you make $50,000 on this job if you sign it.
Yep.
But then you look at the contract and you get advice, it costs you a couple of thousand. If you can't afford that in that scope, then you shouldn't be going after those jobs, right?
That's so true. You have to make sure that the job is something you can handle. That's where you're going to get stuck. If you can't get advice on it, the chances are there's going to something will happen.
Yeah.
I have no doubt in my mind. Something will happen. And if you don't think that the other party is going to hold that contract to your face when something goes wrong, they will. They'll say, well, it's here black and white, Chris. You've said this is the only way you can get an extension of time. It's here. Has any of these happened? No. Well, too bad. Keep going. And you're not getting paid for it. Sorry. Bye.
And the verbal or the handshake means nothing anymore.
It means nothing. No. My dad's a concreter, and everything back in the day was handshakes. And it's not like that anymore. People will turn on you in a second in a dispute, and they won't remember anything, and they'll say, no, that never happened. And if you don't have proof of that, you have nothing.
Yeah. Now, you said before, like, we know at the moment the market's quite tough, right?
Yeah,
everybody is facing some financial issues, whether it be cost of living or, you know, trying to get paid from projects.
Yeah.
How have you seen your sort of industry shift in the last couple of years after COVID, and how a lot of builders are starting to go bust now? How have you seen the industry shift?
I think it again comes down to, well, firstly, the contracts that they're signing. They're so tedious and one-sided that when something happens, the builder has no options and they get themselves stuck. And then that has a flow-on effect with not getting paid. And then if they're not making money, then they're heading down that insolvency route. It's a lot to do with that. And I also think the second issue is trades aren't very good with maintaining their debts. A lot of trades just keep racking up their debts. It's tax time. So little tip, if it's tax time, look at your receivables on your tax return, your business tax return, whatever it is. Look at that figure. If that figure's over 100,000, there's something seriously wrong with your business model, and you need to have a look at it. You need to start tackling your debts. Make sure you're proactive about your getting paid, and that will put you in a better position to not have to go down that insolvent route. Because if you don't get paid on one job, it has a flow-on effect for other sites and other jobs. That's just how it is.
Yeah, I think it's very important to know your numbers.
Yeah, absolutely.
And review them. People should be really reviewing your numbers every day, every week,
all the time,
knowing what's going on. Right?
I'm so proactive with invoices. I haven't had an issue, probably because people wouldn't not pay me. I've never had an issue in all this time, touch wood. But a lot of clients are uncomfortable chasing debts, and I don't understand it. You've done the work. You deserve to be paid. Just chase the debt. Get on the front foot. Call your customer. Don't email straight away. Call them. Hey, you've got the invoice. I know you said you'd pay it. I really need it paid by tomorrow. Be forward about it, because you deserve to be paid. The longer you leave it, the harder it is to get that debt back. That is just how it is.
Yeah, some people won't pay you until you chase them.
Literally, yeah.
And calling them is important to be on the positive end, because if you're
Absolutely.
just sending emails,
They'll just delete it.
or they just won't respond.
Yeah,
They might get upset at you for emailing them. How dare you ask for your money?
Yeah, people don't like calling anymore, but and my message is always about putting things in writing, but I mean calling them for that first conversation. Hi, you owe me X amount. I'm just wondering when that will be paid. And then following it up with an email is always good, just to have a paper trail. But get on the phone, call them. If you're on site, speak to them in person. Why haven't you paid? Like, I just need to understand. I need this paid by tomorrow. Just keep being proactive about it.
Talking about paper trails.
Yep.
What paper trail could help save your case?
Anything where the contract has been deviated from. So scope, pricing, all of the timing. If you have a paper trail of where both parties have signed off, both parties have agreed, your case will be pretty clear. But if you have deviated from the contract and now you've issued a variation for $50,000 and the other party saying, I didn't approve that, you're not getting paid, and you've only got a phone call to Bob and Bob said, I didn't speak to you. Well, how are you going to, it's your word against theirs. It's really hard to prove.
But if you've got an email quote to Bob,
Perfect.
and Bob's responded with, yes, please proceed.
Yep.
Is that enough?
So much easier. You would just attach that to an affidavit. You would say on XY day, Chris emailed Bob. Here's the email. Bob approved it. Here's the proof. They followed the procedure of clause blah blah blah, and this is our position. It would come across a lot stronger than Chris called Bob. Bob said something of words to the effect of. That's how you have to word it in an affidavit, a statement. You have to say words to the effect of, because it's based on your best recollection of an incident. And that doesn't sound it's not as good as having clear written evidence.
Yeah. All right, laying the foundations. How much legal protection should a builder or supplier have before they even step on site?
Yeah, so number one, obviously a contract, whether that's terms and conditions specifically drafted for your business or your building contract, whatever it may be, absolutely that at a minimum. And making sure that accounts for all the work that you're going to be performing, the price that you're agreed to be paid, timing issues, all of that. Insurance, again, you have to have your insurance. You have to make sure your insurance matches the contract. And you want to make sure that you have met any site-specific instructions from the client before setting foot on site. So as I said before, a lot of them have like work health and safety things you need to do, inductions, etc. You want to make sure you do that first.
The horizon scan. Are there any new legal risks or trends builders and suppliers should be preparing for?
I think it goes back to what we discussed before around the insolvencies and the lack of payments and things like that. So you really need to make sure, as we said, if you can't financially keep up with a job, you shouldn't take that job on, because it's just going to bury you even further. And sometimes, unfortunately, you have to learn by experience. In business, we all do. We all have hiccups and ups and downs, and you have to learn the hard way and pick yourself up and keep going. But you need to make sure that you're financially equipped to take on a business and take on a job and a site and whatever that means. And also managing your debts, because they're the key issues I see with respect to financial risk for people in the construction industry. And if you don't get on top of your debts, they snowball so quickly. Before you know it, you're owed $300,000 and you might not see that money again.
Talking about debts, personal guarantees.
Yep.
What's your advice around directors of proprietary limited companies signing personal guarantees?
My preference is not to have them. I always look at the contracts individually and give that specific advice around that, but my preference is not to have them. But the other side's preference is to always have them. So it's just a point of negotiation. Generally, you'll have to give something more to get rid of that. So, for instance, the most common way I see it is in a commercial lease. It's standard practice that the director of a company give a guarantee, a personal guarantee for the provisions of the lease. If you don't give something in return, such as like a longer bank guarantee or something like that, they're likely going to say no. If you're a fairly new business and you don't have backing behind you, it's unlikely they're going to agree to take that out. So it's not uncommon, but it's not. I prefer not to have it in there.
So for trades with suppliers, so most of the time you can get away without signing personal guarantees.
Yeah.
Would you also recommend that they don't sign those as well?
Yeah. It depends on the circumstances and what it's for and things like that. If it's for like a credit application, I would recommend generally speaking, you would have to get something like that.
Yep.
Because it's on credit.
Yes.
But yeah, it depends on the type of the contract and the work and things like that.
Because I think that's where some people come unstuck as well, is they've got a lot of guarantees out there and they don't know who they're signed for what.
Yeah.
And then as they grow, you've got other people in your organisation or your company that purchases items that you might not be across.
Yeah.
And you're then personally liable for that as well, right?
Yeah, you need to make sure if you've got staff, if you're a bigger business, that you aren't getting a director's guarantee signed off by your administrative staff without you looking at it first and getting advice potentially on it, because you don't know the long-term ramifications of that. And exactly, you could end up with 10 personal guarantees and you don't even know about it.
Yeah. Climate check. Is the legal environment getting tougher for people in the industry, especially small custom builders and specialist suppliers?
Yeah, I think it is. It's the continuous flow and effect of the cost of living. I feel like smaller businesses are feeling the impacts of that, and people are getting a bit bolder with staying firm and saying, no, I'm not paying you, or holding them to the contract and things like that. As I said before, if you're equipped and you know your position, you know your risk, you're just in a better position already on the front foot whenever that first dispute comes up, to negotiate on your business's behalf before you even need to speak to someone, right? You've been given advice, here's your contract review, here's the summary. You go to the other party, you say, well, clause X says that I have to do this by this day. It just makes you look better professionally, and it puts you in a better position to try to hurdle any disputes before they start to escalate where you might need to get advice.
So we've come up with a couple of things previously where we had an original contract and things went a bit south, the relationship soured, and we then was requested to complete some work, and they were going to terminate the contract. I think there's a document for that, which then enables us not to be liable for anything moving forward, and then we don't have any claims with them. What's that document called?
So it'd be something like a deed of release.
That's right. Yep.
Yeah. So if it's a contract where you're both agreeing to terminate, you'd want to get something like that signed off. This is particularly important for both consumer contracts, and that's homeowners, and any contracts where your client is an entity, because you want to make sure that it's agreed, this is the end point. I'm not responsible for any works moving forward. I'm only responsible for works up to this point, and that will help with your warranties and things like that as well. If you're going to exit mutually, you should definitely have a document like that prepared.
Now, with the deed of release, how do you come about creating one of those?
Yeah, so you'd need a lawyer to do that for sure. They're an important document, and you want to make sure it's suitable for the contract and that it meets the needs of the contract and both parties, and that it includes what you need it to make sure you can walk away cleanly.
Yep. And terms and conditions, we spoke earlier on that. We've got some pretty lengthy terms and conditions in our contract that you obviously helped us with. What's some tips that you can give listeners that were thinking about doing a terms and conditions for their customers?
Yep. So if you're undertaking any type of work and you don't have a contract in place, the terms and conditions is a good option, because it can outline all the processes that you need to engage your client and what happens with payment and what happens if things go wrong. It's a really important document. You should be getting all customers to sign off on it in writing, and that way you have that on record if anything goes wrong. You want to make sure that it includes things around the scope and payments, any insurance requirements that you need to. You want to make it balanced for the client as well. So not just all about you, but a bit about them as well to make it fair so they're more inclined to sign it. And then, sending them a copy and things like that saying, here's our terms and conditions. I find in my experience, most people are happy to sign terms and conditions because they understand that, you need to protect your business. If you're presenting it to them in a professional manner, they're more inclined to sign it and you can move on with your business.
And how many times do you see people not get those reviewed by legal advice and just sign on them?
Yeah, all the time.
And what are the negatives to doing that?
Well, what I have seen is people taking terms and conditions from another business. That's the main thing, or Chat GPT or something like that.
AI.
AI.
Yeah.
Something like that. And for example, one client came to me last year and she had terms and conditions that she took from someone else and had been having her customers sign off on it, and it had the different entity name on it. So
Wow.
they're not enforceable because it's not her business.
So it's null and void.
It's null and void. Her business has to sign off on it. It's just stuff like that. And like the way she would run her engagement wasn't what it said in there. And again, people don't think about this stuff. They're, it'll be right. Joe Bloggs from the painting shop down the road uses these terms and conditions. They'll be fine for my business, but they're not. Because they're not designed for your business. Sure, they do have a general, well, from the ones I draft, they have a general flavour of things that I always include, but they're always client specific to their needs, always.
I mean, you think you're going to save a little bit of money by copying someone's terms and conditions, right? But then what happens if you do that and they don't pay you?
Yeah, then you got nothing. If the terms and conditions haven't been drafted properly and signed off properly, that's important. Then you do have, look, if you perform services, you have a claim called quantum meriut. It's a equitable court principle. It means that you've performed services so you're entitled to be paid, but you have to prove that.
Yes.
So you need some form of proof of engagement.
Yes.
If you don't have terms or something, you've just got he said against she said again.
And then once it's installed, you can't remove it, can you?
No.
So that's another thing that I've obviously learnt in the time that I've been in business. We've done multiple projects where we've installed windows and doors for residential projects, and then there's been a dispute and the client didn't want to pay. Legally, we're not able to just turn up and remove that window to get paid. So once an item is installed on site, it's now their property.
That's
correct?
Right. Yeah.
And you have to prove that they owe you money.
Yeah.
How does that work for those that don't know?
You'd have to prove that they owe you the money. So you'd have to go down either the Security Payment Act route or the Civil Court Procedure Act route and prove the debt.
Yeah.
You have the onus of proof, the burden of proof, as the person who's instigating the debt recovery. So
it's like you have to prove that they're guilty, that they owe you money before. So it's not the innocent ones that actually have the law on their side until they can prove it.
No.
Otherwise,
yeah, in civil, it's you bear the burden of proof. You have, as the applicant or the plaintiff, you have to prove that what you're saying is true.
One golden rule: if you could give us one piece of legal advice to every builder or trade professional listening right now, what would it be?
I always say this to clients. In nearly 15 years, I have never once had someone say, I regret getting that advice on that contract before signing. Ever. Never. But I can't even tell you how many times I've had the opposite. I regret not getting that advice. I wish I had sent you that contract, Taryn. I've signed this. I didn't really understand it. I thought it'd be okay. Now we're here. I can't get out. And then their options are limited. So key takeaway is don't sign something you don't understand. And it's okay if you don't understand it. That's your job isn't to understand it. Your job is to leave it to the professionals that do. They do this day in and day out. Seeing someone that specializes in business and business law that does this all the time, and then you are in a better position to manage your risk and exposure. And a lot of the time, if I've reviewed a contract and given advice on it, and we've negotiated and we've come to an agreement, most of the time the parties smooth sail. It's the ones where they haven't from the start. If it's not right from the start, it has a snowball effect. If something isn't right at the start, if there's red flags at the start that haven't been identified, it's going to keep happening. Even with contracts I've reviewed where I've said to clients, look, this doesn't feel right. There's a lot of red flags here. And their client is telling me by instructions, oh, they want us to do this, some dodgy things or something like that. It's generally those ones where you're like, you need to have a real think about proceeding with this job. You all just walk away now and cut your losses.
So it's not just the contract side of things that the red flags are. It's if they're trying to get you to sign something that's dodgy,
always.
What does that do then for your brand being associated with that type of company as well, right?
No, it's not good. If someone's pushing you to sign something really quickly, you question why. Why do you want me to? Why do I have to sign this within a day? That's not reasonable. The first thing you can do to mitigate that is to say, look, I want to get legal advice on it. They'll change their tune very quickly, right? But I don't like the pushing of the contract. I understand that these things are time sensitive, and they are. They are time sensitive. You want to get the contract signed within a reasonable time frame, but that's not here at 3 p.m. Sign it by tomorrow. And
what's a reasonable time frame?
I would think for a construction contract, like at least a week to be able to engage a lawyer who has the time to sufficiently review it and get back to you with any departure request would be reasonable.
Yep.
A week to 2 weeks, depending on.
And how do you find a good solicitor?
Well, you should be looking for someone that practices in the area that you run your business in. So you don't want someone who, in my opinion, this is my opinion, you don't want someone who does a little bit of family law, a little bit of conveyancing, a little bit of criminal law. You want someone who handles commercial business matters because you know that they will be familiar with your needs specific to why you're seeking advice. And you can also go onto the Law Society website and there's a find a solicitor.
Yes.
If you're thinking of engaging someone, you can search on there, type their name, you can see how long they've been practicing for. Google reviews are always important. You want someone who's got some backing behind them and a good reputation amongst the community. I think that's important as well.
Yeah. And different states.
Yeah.
Different laws?
Yeah, there are. Yeah. So you want, if your work is primarily in New South Wales, you'd want a New South Wales solicitor. And also if you have a business that runs Australia-wide, some things are carried across the board, but some things aren't.
So have you found that that's been an issue in the past with clients that they've worked in different states but their contracts weren't up to speed for that particular state?
Yeah, you can come unstuck because, for instance, like the Security Payment Act, that's state specific. So if you're referring to the wrong act within your invoices or whatever, then that'll obviously void it. Most of the issues can be handled by a lawyer, but it's when you need to take it further, like to court and things like that, you'd want someone in that state because it's completely different in each state.
Well, Taryn, look, I really appreciate you coming in today and having a chat to us. If you can just tell everybody how they can find you. I know you're on Instagram, but if you can tell everybody what your contact details are, and we know that Taryn's in the Sutherland Shire.
Yep.
It'd be great if you could share that.
Yeah, so my website is www.cowanlaw.com.au and my business is Cowan Law, so COWAN, and we're on Instagram as well. So, yeah.
Thanks, Taryn. I really appreciate it.
Thanks, Chris.
Thanks.